Welcome back to another episode of Tutorials with Ike. Today, we're going to continue with the legal environment questions, and we're on section B right now. And section B is short answers, so it's not multiple choice questions, they are short answers. And we're going to be looking at how we are supposed to answer them and everything. They are usually very strict when it comes to this part, so please take notice and let's comment with it. So, number one says, so there are 10 questions, so each question will give you 3 marks, so that's 30 marks. So the section A was 30 questions, 1 mark each. This one is 10 questions, 3 marks each. So it's important to take it very serious. Okay, so the number one says, what is an offer in contract law? All right, so what is an offer in contract law? So offer is, in simple terms, talking about the proposal aspect of the contract, you making your intentions known, to the offeree, yes. So if you are the offerer, you making your intentions known to the offeree. But then let's look at the answer from the slides, which is UPS's slide. So UPS's slide says, an offer refers to a proposal which a person called the offeror makes to another person called the offeree, in which the offeror expresses his willingness or intention to enter into a contract or to do business with the offeree if the offeree accepts the offer. So yes, this is straight from the slide. So if they ask you what an offer is, you can't talk about an offer without mentioning the offeror and the offeree. You have to make mention of it. And you also have to add that it's he making a proposal. You get it? That's the proposal aspect of a contract. So yes, so that's from the slide. So if you are given a question on it, that's how you go about it. So that's for question 1. Now let's go to question 2. So question 2 says, can silence be considered acceptance in contract law? Can silence be considered acceptance in contract law? Okay, so generally, silence cannot be considered acceptance. That's the general one. But in exams, you can't just say no. You have to give a case to support it and all that. If there are exceptions to, you have to add it. So for this one like this, there are exceptions. Do you get it? So we have to talk about all that. So let me read a suggested answer. So can silence be considered acceptance? So this is a suggested answer. So it says, silence cannot be considered acceptance in contract law. The offeree must communicate acceptance clearly, either through writing, conduct, or words. Silence is typically considered ambiguous, as shown in the case of Feldhaus versus Bindley. In Feldhaus versus Bindley, Feldhaus offered to buy his nephew's horse and said if he didn't hear from him, he would consider the horse his. The nephew didn't respond, but the auctioneer mistakenly sold the horse. The court ruled that silence does not constitute acceptance and no contract was formed. So you have to add a case to support it, just like this one. Now you also have to know that there are exceptions, so you have to also talk about it. So let's look at the other part. So you can also continue and say, however, in certain cases like unilateral contract, example, Carlio versus Carbolic Snowball, where Carbolic Snowball said, if anyone used it and gets flu, they will get £100. Carlio used the smoke ball and got the flu and sued for the reward, and the court held it was valid, even though she had not explicitly communicated acceptance beforehand. So yes, so in the case of performance, where you have to perform an action, you have to add that this one is an exception. So yes, if you are given a question like this is how you have to go about it. You have to add cases if they are necessary. If you don't know the cases, then that one, just try and explain it. All the words, just write it. At least that one, you'd be able to, tell the lecturer that you know something about it. But if you are fortunate to know the cases, then you add it to it. So yes, that's for number 2. Now let's go to number 3. Number 3 says, what is the difference between executory and executed consideration? Okay, so in simple terms, executory consideration is a situation where the parties to the contract or the parties of the contract have not fulfilled their obligations yet. And executed consideration is when they've already done it. You get it? So let me read a suggested answer here. So it says, an executory consideration is a contract where both parties still have obligations to fulfill, while an executed contract is one where both parties have completed obligations or their obligations. So yes, so for executory contracts, let's assume maybe you go and buy goods, and they are supposed to deliver it to you the next week or the next 2 weeks. That one like this is executory because they've not yet fulfilled their part. Do you get it? But if let's say you go to the market and go and buy something, that one you've given the market woman the money. She has also given you the commodity. So that one is executed. Do you get it? So executory is when the obligations of the parties have not been fulfilled yet. But executed, they've been fulfilled that instance or that moment. So yes, that's for executory and executed consideration. Now let's move on to number 4. Number 4 says, why is consideration important in a contract? Okay, so before we have to understand what consideration is more like the value proposition in a contract. So if you are dealing with cars, the car is the consideration. If you are dealing with money, money is the consideration. If you are dealing with an aeroplane, aeroplane is the consideration. So consideration is what is of value in the contract. Do you get it? Or the value proposition. Now the question is asking, why is consideration important in the contract? Now, consideration is important because if there's no consideration, the law cannot enforce it. You get it? They can't protect you because at the end of the day, there's nothing of value. So what can they sue you for? Or what can the person sue you for? Do you get it? So let me read the answer we have here. So it says, consideration is important because it makes a contract legally binding by ensuring both parties exchange something of value. Without it, the agreement may not be enforceable. Yes, so exactly. Without consideration, the argument cannot be enforceable by the courts. So yes, so that's for why consideration is important in a contract. Now let's go to number 5. Number 5 says, are all agreements intended to create legal relations enforceable? Are all agreements intended to create legal relations enforceable? Okay, so generally, not all agreements intended to create legal relations are enforceable. The ones in domestic settings are usually not considered enforceable. They are taking that, oh, it was in a domestic setting, so you're not really serious about it. But in a commercial setting, yes, it's enforceable. So let's see the answer we have here. And this one, so if you have a case, you can add it to support it. So let's see the answer we have here. So it says, not all agreements to create legal relations are enforceable. Agreements made in a domestic setting are presumed not to create legal relations. For example, in the case of Balfour versus Balfour, the court held that an agreement between a wife and a husband to send money was not enforceable because it was made in a domestic setting. Yes, so exactly. So you just have to talk about the fact that when it is made in a domestic setting, the courts will assume that it's not enforceable or you're not really serious about it. So you can add a case of Balfour versus Balfour to support your answer as well. So yeah, so that's for number 5. Now we move on to number 6. Number 6 says, how can a contract be discharged by performance? How can a contract be discharged by performance? Okay, so generally, a contract can be discharged by performance once both of the parties have done their obligations or they fulfill their obligations. But you can't just write that. You get it. You have to add the exceptions and everything. For example, if the performance is divisible, let's say it's in parts, once you do a part of your work, so let's say you invite maybe a contractor to build a house and you tell him that, oh, once he's done with the ground floor, you pay him this, the first floor, you pay him this. Once he's done with the ground floor, you're supposed to pay him. You can't say that, oh, maybe you're supposed to finish everything. Once you guys decided that you're going to pay him in bits, it's divisible. You get it. So you talk about all that. And if also someone prevents the party from doing the work, you have to compensate the person. You get it. If someone prevents you from doing the work, if the other party prevents you from doing the work, you have to compensate him. You also have to compensate him for substantial performance. So let's read the answer we have here. So it says, a contract is discharged by performance when both parties fulfill their obligations as agreed. However, exceptions exist. If the contract is divisible, performance of each part discharges that part. If partial performance is accepted, the party must be compensated for the completed work, which is also called substantial performance. So we have the case of Mafsud versus Farabros, where the court held that accepting partial delivery of goods obligates the buyer to pay for the accepted portion at the contract rate. Yeah, so that's for the partial performance. So if you've done a substantial amount of it, you get it, or you've done a good amount of it, they can't say they won't pay you for it. You get it. If let's say you're supposed to deliver maybe 100 goods to them and you've delivered 80, they can't say they won't pay you anything. They have to compensate you. So that's for the partial performance or substantial performance. Then we also have, if one party prevents the other from performing, the performing party can seek damages. Yes, which is the same as what I said. So we have a case of Planche versus Colburn, where the author was hired to write a book, but the publisher cancelled the project before it was finished. The court decided that the author should be compensated for what he had done. You get it? So yes, this one, it wasn't his fault. It was the other party that caused him to stop his work. You get it? So it wasn't his fault. So that one, you have to also compensate the other party. So yes, that's for how a contract can be discharged by performance. So you have to talk about everything you know about it. You get it? Okay, now we move on to number 7. Number 7 says, how does a mistake vitiate a contract? How does a mistake vitiate a contract? So a mistake is where one or two of the parties are mistaken about something in the contract or an important element of the contract or anything about the contract. Yeah. And we have unilateral and mutual mistake or common mistake. And if it is unilateral mistake, if one person is mistaken about it and it's the person's fault, the court cannot do anything about it. It can't protect you. But if it's by fraud, if the person frauded you, then that's when you can sue the person. You get it. So for that one, the contract will be discharged. That's if it's by fraud. But if it's your fault, then that one, the court cannot do anything about it. If it's also a mutual mistake or a common mistake where both of you are mistaken about something, then the contract can be discharged. You get it. So let's look at a suggested answer and see how we go about it. So it says, so the question is, how does a mistake vitiate a contract? So it says, mistake in contract law refers to situations where one or both parties are mistaken about key elements of the contract. So you first explain what mistake means. Then it goes on to say, mistake can vitiate a contract in the following ways. One, unilateral mistake, where one party makes a mistake. The contract is valid unless the mistake is caused by fraud or misrepresentation. So you can add a case to support it. So we have Smith versus Hughes, where a farmer mistakenly bought new oats instead of old oats, and the court held that the case was valid because it was his fault. You get it? So once it's your fault, if the person has not frauded you, if you don't do your part by checking or ensuring that everything is on point, and the person has not frauded you, then that one, the contract cannot be vitiated. So that's it for the unilateral mistake. So we have the common mistake or the mutual mistake. So for that one, both parties share the same belief about a fact or a fundamental fact, rendering a contract void. So for this one, we have the case of Bell versus the Lever brothers. So the court held that a contract could be void due to a mutual mistake about a key element. In this case, the employees were not entitled to compensation, and both the employer and the employees didn't know about it. Yeah, so this one, the court vitiated the contract because both of them didn't have any idea about it. So once both of them don't have any idea about it, the contract can be vitiated. So yes, so if the question comes like this, you talk about both the unilateral and the mutual mistake or the common mistake. Don't just talk about one of them. All right, so that's for number 7. Now we move on to number 8. So number 8 says, how does illegality impact the validity of a contract? How does illegality impact the validity of a contract? So this one is just simple. Once, there's something illegal about the contract, obviously they can't enforce it. Do you get it? So the contract is not enforceable. And this one, you also have to add a case to support it, where maybe someone did something illegal or something, and the contract could not be enforced. So let's read what you have. So it says, illegality can render a contract void or unenforceable if the subject matter of the contract is illegal. The agreement is considered void. So for this one, we have a case of Bedford Insurance versus Institut de Residuos de Brazil. So for this one, a contract with an unlicensed insurance company was considered illegal. So the contract was not enforced. Do you get it? So yes, that's how you go about it. So you just add a case if you know any of them. If you don't know, then you can just explain it in your own words. Then we move on to number 9. So number 9 says, what is the law of agency? So agency just talks about how someone acts on behalf of the principal. That's it in simple terms. So let's look at a suggested answer we can give. So it says, this deals with the relationship which exists between a principal and an agent, whereby the principal consents either expressly or impliedly that the agent acts on his behalf in respect of transaction with other people. So yes, that's a suggested answer. So yes, that's it about the law of agency. So you're just acting on behalf of the principal, yes. Okay, so that's it for number 9. Now let's move on to number 10. So number 10 says, what is the rule of caveat emptor? So caveat emptor just means let the buyer be aware or let the buyer know. So what it means is that if you are going to buy something, you have to check to make sure everything is on point. If not, you can't complain about it. You get it? So you have to do your job by checking to see everything is on point. So let's read a suggested answer we have here. So it says, caveat emptor is a Latin term which means let the buyer be aware. It means the buyer should examine goods before purchasing and assume the risk for the quality unless there is misrepresentation or breach of warranty. You get it? So unless the person has frauded you. But if not, you have to make sure that you've checked everything about what you are buying. Yeah, so that's all for the short answers part, which is the section B. So if you're able to get everything correct, you're going to get 30 marks. There are 10 questions and 3 marks each. So everything correct to give you 30 marks. So this part, you just have to make sure that you master the cases very well. And yes, you'll be able to excel in this particular part. So yes, that's all for today's video. If you like this video, please don't forget to like, subscribe, and share with your friends if you think it will be helpful to them. And I'll see you in the next video.